I'm going to talk now about intangible assets. I'm using the word intangible quite deliberately. You've probably heard of intellectual property. Intellectual property, to a lawyer at least, consists of things like copyright, patents, trademarks, where there's a particular law that says this is how this item of intellectual output is going to be protected. Patents obviously deal with inventions, trademark deals with how you badge or brand your business, and copyright is the way you protect the written word. But in most businesses, there's a lot of other things that aren't things you can touch and feel that make up the value of the business. It might be the processes that you follow, the culture that you've inculcated in your staff, the way you do business. This may be know-how, it may be things that just pass by word of mouth from a supervisor to people that work with that supervisor. But in most businesses these days, this is what constitutes the value of the business. It's something that's not tangible. It can't be handed across like a chair or a car or a piece of real estate. It's an intangible thing, but it's what people pay money for. And so we just need to talk through how you manage and protect these because of their very nature. It's easy for you to lose control of them. And the way you manage them is through a number of different stratagems involving getting more contracts, I'm afraid, but also it's about the way you brief and instruct your staff about these assets. The other thing we just need to understand at the start is that information, ideas themselves are not protected. So you might have a brilliant idea for a book or a film, you might have a brilliant idea for a business. That idea, if you tell someone, they're free to use. There is no protection. Even when you write that down in a business plan or a script or the book, the protection that you get from copyright only protects what you've written down. It stops someone copying the printed or written material or the code. It does not stop someone looking at that thing and saying, I'm going to write my own script, make my own film, make my own music based on what I've seen, because they then will own copyright on what they've developed. So one of the key things you need to have in your kit bag is a non-disclosure or confidentiality agreement, because the way you protect these ideas is by requiring the person you tell them to keep them secret. Now you can do that verbally. You can say to someone, I'm going to tell you something very important, please keep it secret. The difficulty again is how do you prove that? And there have been a number of cases over the years, a lot in television and entertainment, where ideas have been transferred and guess what happened? The television station has said no, they're not interested, but 12 months later has produced more or less the same show. So have a confidentiality agreement. The difficulty is you will find that when talking to investors particularly, they will say, we see too many ideas and we're not going to sign any confidentiality agreement. So you need to have a strategy again of having some information you can share without an agreement, without any secrecy, to hook people in, and then when you want to go to the next stage of the relationship and give them perhaps some financial detail or access to the code or access to designs, you get an agreement signed. And most investors will agree to do that. And if they don't, then you should not be dealing with them. So again, you see already that you have an agreement, but you also need to have a process that allows you to engage with people rather than just simply saying, I'm not going to tell you anything until you sign the agreement. You're not going to get very far. The same comes with your employees and contractors and other workers. You'll have an employment agreement that says, keep these things confidential, these are secret, don't use them somewhere else. But again, in addition to that, you need to ensure that that's a culture that you foster in the business. If you have a culture where you are encouraging people to rip off other people's intellectual property or to bring with them from their previous employer what they were working on there, then you're going to set up a culture where people think it's quite all right to do that when they leave your business. The other thing, particularly if you're working in a highly sensitive area, is making sure that in addition to the clause in the contract that says that you can monitor email traffic on an employee's computer, that you do. It's surprising the number of clients we've had who have found things. Often they wait until it's too late when the employee's left and find that a whole lot of confidential information has already left the premises. But there's nothing to stop you doing that on an ongoing basis, again, so long as you have properly disclosed that level of surveillance to your employee. You may also want to ensure that when someone's leaving, that as part of the exit interview, you remind people about their ongoing obligations regarding your confidential information and intellectual property. And indeed, in some cases, you may even want to write to them 3 or 6 months after they've left to continue to remind them. And people often say, that these things are not worth the paper they're written on, no one's going to take action. But at any one time, we've always got 1 or 2 cases on where employees have left and where action is either actually being taken or is being threatened. So this is an area that is a subject of a lot of disputation, so you just need to be aware of that. The other thing is that some intellectual property, like patents, achieve their status through registration. Copyright, there is no system for registration. You achieve copyright in something when you've written something down, instantly copyright exists. And in other cases like trademarks, you can have trademarks that are unregistered, or you may choose to register it. It's our recommendation again that you don't rush into spending money on registration, because it can become expensive, and oftentimes people will evolve their branding and their name in the first 12 or 18 months. But if you do have a logo that you think captures your identity and a name that you think is not going to change anytime soon, then it is always worthwhile registering it and carving out for yourself exclusively the use of that name or that logo. The other thing that is particularly important is keeping a track of what your intellectual property and your intangible assets are. In terms of tangible assets, if you had an office with furniture and a fridge and computers, you have an asset register that you attach to your tax return as you depreciate your items. Even though you can't depreciate IP, we suggest you do the same thing, maintain a register of that IP. And this is particularly important if you're coming to do a capital raising where an investor may want to see what IP you have and to do their own validation of it. It'll certainly be important when you come to sell, and it's not something that you can backfill quickly at the time of a transaction. Much better do it as you progress. And it's also important because it's also likely, as you're developing your solution, that you are using third-party IP. This might be stuff that you've licensed in. More likely it's going to be open source software that your developers have used. And it's always important that you're able to tell an investor or a buyer of your business what the rules are relating to that open source software. Generally speaking, large companies, if you're selling to a large company or a large investor is investing, do not like open source software because there's always the risk that one of the license conditions relating to the use of the open source software has not been made, and larger companies present a bigger target from people who may be trying to get some compensation for that unauthorized use. So again, you not only need to keep a list of what the asset is, but how did it come about? Was it made in-house? And if so, was it by an employee or by a contractor? And if so, where's the contract? If it came from outside, where's the license agreement? What are the open source rules that relate to that bit of code? And very, very hard to be doing this in response to a due diligence question. Much, much easier to do it aggressively as the business evolves. And I think the final thing, if I can just say, is the key to this and having that list, make sure that you own the intellectual property or the intangible asset. And the only way of doing that is not like a car where you've got a registration certificate, is you need to prove through the chain of contracts how you came to own it. Was it something that was developed by an employee and there's the contract? Did you buy it in? Was it part of buying the assets of another company? All these contracts need to be kept and easily accessible when someone comes in to have a look through it. If you're looking to sell the business, sell those assets, or even indeed if you're trying to raise money on the value of your intangible assets.